Welcome to the Judicial Committee of the Privy Council in London. Today we are hearing an appeal in a commercial dispute between Pickle Properties Limited and Mr. Stephen Plant. It concerns an action by Mr. Plant to obtain an equal contribution from Pickles, the appellant, as a co-surety in a joint and several guarantee which the parties granted to a financial institution. The case originated in the British Virgin Islands, and the appeal is taken with the leave of the Eastern Caribbean Supreme Court Court of Appeal. Today, the appellant's case is presented by Mr. Ronnie Tager QC and the respondent's case by Mr. Nicholas Peacock QC. Before inviting Mr. Tager to open his appeal, I will introduce the panel. I am Lord Hodge, and sitting with me today is Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Hamlin.
Good morning.
And Lord Stevens.
Good morning.
I now invite Mr. Tager to begin his submissions. Thank you.
May it please you, my lady and my lords, I appear in this matter together with my learned friend, Ms. Rosamond Baker, and Mr. Peacock, leading Mr. Joseph Bunting, appear for the respondent to this appeal. I think it will be convenient to the board if I present my submissions by reference to the case that we lodged in support of the appeal.
Mr. Tager, the board has had an opportunity to have a preliminary discussion, and while I don't wish to take you out of order, I think when you are addressing the cases, we would welcome a focus on the equitable case, because the judge did treat the contractual case as a bit of an add-on at the end of his judgment. But subject to that, I'm happy for you to present the case in the way you want.
Well, I'll deal with grounds 3 and 2 in reverse order.
Thank you.
But I will touch on matters relating to both of the grounds when I address the board in respect of ground 1.
Yes.
We make the two submissions set out in paragraph 6 of our case. It's not a two-stage case, as I think my friend Mr. Peacock suggests in his case. It's two separate submissions as to how, in a matter like this, the appeal court should have and the board now should consider the case of a delayed judgment. The delay in this case was either 9 months or 12 months. It was 9 months if the judge, in September of 2015, when the parties lodged their closing submissions, read them at that stage, and in addition to reading them, perhaps cross-referred to the evidence and to the documents that are referred to in the parties' respective closing submission. But if he did not, if the closing submissions were merely added to the file, which he only took out in June of the following year, then indeed the delay is 12 months, and we have no explanation from the judge as to what happened during that 12-month interval, and therefore we submit to the board that the presumption should be that there was a 12-month delay between evidence concluding on the evening of the 1st of July and the date probably at the beginning of June a year later, when the judge got round to preparing his judgment in this case. The only point I would make supplementing the submission set out in paragraph 6A is that the advantages of the trial judge are not merely watching witnesses give their evidence and forming a conclusion as to their demeanor, as to the extent to which that witness is either telling the truth or was otherwise to be treated as reliable, There is the whole experience of the judge during the trial, which would be vivid in his memory and recollection in the days and weeks following, but which would be gradually lost over the ensuing year. It is something that might have been revived had he looked at the closing submissions in September and put them aside to be dealt with at a later date. But otherwise, you have had a continuous fading of the experience of the trial, as well as the recollections he had of the demeanor of witnesses and other matters that happened during the trial. We do not have the judge's notes. We have no idea as to what extent he was noting the evidence as he went along or noting other matters. He knew that transcripts were being prepared, and there was never a chance of an extemporary judgment at the end of the case, because the timetable was very tight and the 2 days of the trial were devoted purely to the hearing of evidence. Those are matters which are plainly relevant to the effect of delay in most cases, but in particular in this case. We cite the case of Goose and Wilson Stanford in paragraph 7. That authority is to be found at 2527 in the bundle. I do not ask the board to turn to it. The paragraph we cite, 113, which is cited in a number of the other cases, is at page 2569. And when you look at that at 2569, I would ask you to glance at 112 before reading 113. The case of Bond and Dunster, which is the next authority that we refer to, is
Mr. Taker, was your reference 2569? Is that right?
2569.
Because that comes up with a paragraph 152. You want to look at paragraph 113?
Yes, I do apologise. I must.
It's 2559.
Yes, that indeed. I'm sorry. I think I misread my note.
Thank you.
And I do apologise for that.
Sure.
The Bond case is at 2050 in the bundle. The paragraph we rely on, paragraph 8, is at 2053. The text case is at 2942 in the bundle. The text case, the paragraphs is at 2942, with the paragraph we rely on, paragraph 7, being found at 2946. And the again, I would also ask you to look at, I won't take up time going to it now, paragraph 49 at 2965 in that case. Our second submission, that if there's any error that could be attributable to the delay in the writing of the judgment and the appeal court cannot be satisfied that the judgment is safe, then the matter is to be remitted for a retrial. If I can just say a word expanding on that. Where you have a situation, as we have in this case, where evidence that is inconsistent with the finding of a judge is not mentioned by him, and a good example of that is the cross-examination of Mr. Fowler, or indeed the evidence of Mr. Fowler and his cross-examination on the issue of authority. It would be wrong after where there's been a long delay, to make an inference that might have been appropriate if the judgment had been delivered shortly afterwards, that the judge had it in mind and implicitly rejected it. That implication cannot be made a year or 9 months after 9 months or 12 months. because after 9 months or 12 months, it is likely. It doesn't matter whether it's more likely or next likely, but it is likely that the judge simply forgot about that evidence. And we have some support in this case because he doesn't even mention the oral evidence of Mr. Fowler when referring to the witnesses who gave evidence at the trial. Paragraph 8 cites the case of Bond and Dunster in support of that second proposition. Bond and Dunster is at page 2050, and the paragraph we rely on, paragraph 7, is at 2052. And I would add that we also rely on the additional comments of my Lady Justice Arden, as she then was, at paragraphs 12 and 13 at 2054. Cobham and Fret is a well-known authority. It is at 2090 in the bundle. The pages we rely on are at 2098 and 2099. And which was also an appeal from the BVI Court of Appeal in a matter involving 12 months delay. What is interesting is that, well, it's a point to be noted that delay itself was not a self-standing ground of appeal as it is in the present case. In the speech of Lord Scott at page 2099, citing Lord Justice Peter Gibson in a case called Times versus Singh, the comment is made that there was no sign that the judge had misread the evidence, and that's a point that I'm so sorry, had misremembered the evidence, and that is something that we quote from a little later on in the case. At page 9, paragraph 9, we rely on the case of Harb and Aziz, although there, as being a recent case, there are other cases where appeal courts have set out what are the requirements of a proper judgment. The Harb case is at 2573 in the bundle, and paragraph 39 in the judgment of the Master of the Rolls is at 2585. But it is convenient, in fact, to start at paragraph 34 on page 2583 and then go to paragraph 39. I make the point because it is really anticipating a submission that my learned friend Mr. Peacock will be making, that there was no suggestion in the Harb case that this was a matter where the deficiencies in the judgment and Mr. Justice Peter Smith's failures to set out fully his reasoning in accepting the evidence of some witnesses and rejecting that of others, that was something that ought to have been raised with the judge to give him an opportunity to rewrite or to expand on his judgment. The rolled steel case, which we refer to at the end of paragraph 10, that's in the bundle at 2791. The citation is from the third judgment in that case, given by Lord Justice Lawton, which was not in fact mentioned by either of the other two members of that panel. That is at page 2855. And again, I make the point that there was no self-standing ground of appeal in that case based on delay. This was just an observation made by Lord Justice Lawton at the end of his judgment, because clearly the delay was something that had troubled him and perhaps the whole court during the course of the hearing. In paragraph 11, we actually are able to cite a provision of the Code of Judicial Conduct, which is in the bundle at page 3075, which refers to the a period of 3 months as being the maximum period for the delivery of a judgment. It's because it coincides with what the Justice of Appeal Courtney said in the CA judgment, that it's a generally accepted yardstick. I need to say nothing more on that. It was clearly a yardstick that, and the relevant period that the Court of Appeal had in mind in the present case. The Bank of St. Petersburg case is in the bundle at page 2008. Although we refer to paragraph 84 of Sir Geoffrey Voss's judgment, one should start at page 2027 of the bundle in paragraph 82 and read forward to 284. Paragraph 12 in the third line, we quote, reading the transcripts assiduously. That is a phrase used by Sir Geoffrey Voss in paragraph 82 of the Bank of St. Petersburg case, and we submit that plainly did not happen in this case. Of course, it should. We then make submissions on the application of those principles to this particular case, and I think the only submissions I shall make, in addition to those set out in this part of our case, is in relation to paragraph 17, where in the middle of that paragraph, we refer to the judge's failure to refer to or consider the oral evidence of Farrow or McBride, in addition to that of Mr. Faller. I'll leave Mr. Faller aside for the moment and just concentrate on Mr. Farrow. And I'll just give you the page references in the records to his cross-examination of matters that were plainly of significance, of which there's no sign that the judge had read them or had them in mind when writing his judgment. Page 926, Mr. Farrow explained that he was not instructed to value on the basis of a short marketing period. His 15 months was plain was in fact plain from his report. His report said that a 15-month marketing period would lead to a sale at £1 million. The shorter period was put to him in the witness box, and you'll see at page 980 and 981 to 982 how he dealt with that. And it is, now you have comments of my learned friend criticizing Mr. Farrow, and if the judge would have referred to this evidence and made those criticisms, we would know why he rejected the evidence of Mr. Farrow. But he doesn't. In the courtroom, he would have known what the significance of a pause. In some cases, as the board will be well aware, a pause is indicative of the witness struggling to come up with an answer, especially if it's a witness of fact who's been caught out giving inconsistent evidence. But where an expert who was asked to value on one basis is asked to reconsider his valuation on another basis, pausing, wanting to reflect, and then a moment or two later coming up with the answer, which he then explains. And when we come to the third ground, I'll go into the evidence in a little more detail. But I'm just identifying the passages which the judge plainly did not have in mind. 983 and 984, at the end of his cross-examination, he identifies prospective purchasers who... Yes, Will.
Just in relation to Mr. Farrow, as I understand it, you didn't rely on this evidence in your submissions at the end of the trial either. You relied on his earlier figure of 1 million rather than this 25% discounted figure. Is that correct?
I think that is correct, but that was in the context of the case being presented then, that if the bank had known that they could achieve a much higher figure, they wouldn't have been pressing for 8 to 10 weeks. So it was in that context that those...
You're criticising the judge for not picking up on this point that you yourselves did not rely upon in your closing submissions at trial.
Well, in asking the judge to, in relying on those closing submissions on a £1 million figure, that was plainly in the context of submissions that 15 months ought to have been allowed for the marketing. But when the judge, when dealing with the valuation evidence, ultimately taking the shortcut of relying on the bids, but before that, plainly preferring Mr. Arnold's evidence on the basis of it being much closer to the result of the that came in compared to the £1 million figure, he was looking at the wrong figure, and where an expert witness changes his figure or changes his opinion on the basis of it having been given on one premise, and when invited to reconsider it by reference to another premise, which is which was ultimately the judge rejected the idea that the bank would have been prepared to wait 15 months, and there's been no appeal against that. But having done so, it was wrong for him to have continued to use a £1 million figure when he was given the £750,000 figure as being the relevant one if there is a short marketing period.
He was given it on the hoof during oral cross-examination. It wasn't a considered figure, wasn't in a report, wasn't explained.
Oh my lord, it was explained.
Not in a report.
If I can take you to page 980. He said he'd have to consider that. And then he was asked at line 21, percentage terms, and answer, typically, it could be a 25% deduction. In this case, it might be more. And just pausing there, typically is because it is a standard feature of valuations provided, especially in the case of mortgage lending transactions, for the prospective lender to ask the valuer to give an open market value based on a reasonable a marketing period, and then a forced sale value based on a much shorter period, and there is a rule of thumb or a convention that may vary from one type of property to another. But when he's using the words typically, he is explaining the basis for that. He was asked for a percentage. He wasn't asked to provide comparable evidence that supported that. So because he wasn't asked that, all we have is his evidence. He's then asked, the questioning then goes on to what the price might be at mortgage, and he, on page 981, discusses that. He thinks that £1 million mortgage would be optimistic. That's line 15 on page 981. Again, he is pressed line 20 on percentage terms. And he says, as I said, it goes back to what I said earlier, it could be 25%, it could be more depending on the circumstances. So he's being cross-examined on the basis that that having fixed an open market value by reference to comparables analysis and the detailed calculations that he had carried out in order to achieve his £1 million figure, which involved separate valuations of the two buildings. He makes an adjustment, which is what he described as a typical adjustment, and was not pressed further on that. And there was nothing surprising or unusual about that evidence. The submission, although I would have been asked this question later, but the submission I make at this stage is that I am identifying evidence that the judge simply either forgot about or alternatively ignored.
Mr. Tager, might it be said against you that evidence that typically a foreshortened sale might result in a 25% reduction, but in this case it might be more, is a rather wobbly peg on which to hang a valuation, because the witness himself is saying in the circumstances of this case it might be more than that.
Where the market comparables that are relied on are all transactions where there was not a forced sale, Mr. Farrow was able to investigate and analyze and present his calculations relating to them so as to achieve his £1 million figure. Asking him to make an adjustment based on a hypothesis which is not reflected by available comparables, and there were no comparables of forced sale transactions that Mr. Arnell had identified, so that there are no such comparables in his report. All the valuer can do, based on his experience over very many years in this market, is to make a percentage reduction. Indeed, that appears to have been the understanding of the Respondent's counsel, who asked the question by reference to a percentage deduction, no doubt because she was used to the fact, having seen many a valuation report prepared for a mortgage lender, that there is a frequent adjustment downwards for forced sale.
Yeah, or forced sale or a foreshortened sale period.
Indeed, in marketing, they amount to the same thing, and of course, common sense suggests that if that the longer you have, the more likely you're going to attract purchasers who are prepared to pay ultimately the highest price that the market will bear.
Thank you.
Sorry, Mr. Tager, before we move on from that, my question is a slightly anterior one. How did Mr. Farrow how was he not instructed that this was a foreshortened sale period when Mr. Sharp himself agreed that it was?
The answer is I don't know. He was also instructed to provide a 2015 valuation, an up-to-date valuation, which might have been of marginal interest to the judge, but clearly was not something that went to any of the issues in the case, other than to illustrate the fact that there were potential profits or a potential increase in value that Mr. Plant anticipated as being one of the reasons he went into this transaction, which had been realized, at least on paper, by the date of trial.
Well, could I ask the question in a slightly different way?
It's a good question. He should have been instructed to value on at least on that alternative basis.
Yep. Sorry, I do apologize. Could I perhaps reformulate the question? Perhaps the whole of his report, if based upon an incorrect hypothesis, should just have been rejected.
If he was a fruit valuer and he had valued apples when he should have valued oranges, of course you reject the report. He's valued the wrong thing, and therefore he's of no assistance to the court. But if you get to a forced sale value via an open market value, but you have to adjust your figure to take account of the restricted marketing period, then, and that is inherent in the way that Mr. Farrow dealt with this on page 980 when cross-examined on this point, then the exercise he carried out is a necessary first step. And the adjustment only comes at the end. And it was because he was cross-examined on this that we actually have his adjusted figure. Had he not been adjusted on this, I'm so sorry, had he not been cross-examined on this, then it would have been very difficult for the appellant to contend that the judge should have paid more attention to Mr. Farrow's evidence than he did. But he was cross-examined, he gave his answer. He explains it by using the word typically. It didn't require 5 paragraphs to explain. He was asked to express it in percentage terms and not by reference to anything else. It was open to the judge to reject the evidence on the grounds that he wasn't satisfied that Mr. Farrow had considered the matter sufficiently, and that may well have been a difficult finding or explanation for a finding for Pickle to challenge, but he didn't. He just refers to the £1 million. And by referring to the £1 million, he's referring to the wrong figure. There's one I should also explain, because there may be some confusion in relation to Mr. Farrow's reports. Mr. Farrow prepared 2 reports. There was an application for summary judgment at an early stage of these proceedings, which was abandoned. His first report was prepared for that. The only information he had at short notice to prepare a report was that which his firm, Savills, had in its files from their bank valuation in 2007. It's clear from that report that he has no updated information on the occupancy or the rents that are being paid, and that he hadn't inspected the property. So it was a highly qualified report. Indeed, it was one which resulted in an evaluation of £1.5 million. and his second report was prepared in order to update the first. By then, he'd had a great deal of updated information, which he in fact took from the report of Mr. Arnell, which he exhibited to his second report. And he had had an opportunity to inspect the property and made various adjustments to his calculations and came up with the £1 million figure. His original report had been based on a reasonable marketing period, and he therefore, unsurprisingly, prepared his updated report on the same basis. I accept he should have been instructed to come up with an alternative figure. He was not, but that evidence did emerge from his cross-examination.
Well, that leads me on to a slightly different question, and that is, presumably by the time he gave his evidence, he'd seen the reports on the other side and was aware of the issue as to a foreshortened marketing period. And his duty would then have been to assist the court in relation to that shorter period.
The answer is no.
Yep.
Both experts were instructed on the specific basis that they were to ignore the actual marketing because that was an issue in the case. And so neither of them based their views or even reconsidered their views by reference to the bidding that actually occurred. Indeed, in the case of Mr. Arnell, he makes it clear in his report that it was only at a very late stage in drafting it that he became aware of the sale price. But he had left he left that out of his mind when he reached his £430,000 figure. So the experts did not see the witness statements. Indeed, it's not even clear that they. In fact, I think it's. I don't know about Mr. Farrow, but Mr. Arnell was on holiday when he gave his evidence and gave it by way of a video conference call. So it's unlikely that they heard any of the cross-examination over the previous day and a half, or the previous trial. Indeed, Mr. Arnell gave his evidence at the end of day one, interposing in the middle of Mr. McBride's evidence. So he wouldn't have known anything about the evidence to come. Mr. Arnell gave his evidence as the last witness, but it's unclear whether he was even in court when that evidence was given. It's clear from his reports and from the report of Mr. Arnell that neither expert was provided with the witness statements. They were just giving sort of classic valuation evidence without reference to the actual issues in the case. So I don't think he can be criticised for being unaware that there was a shortened marketing period. And indeed, that's not something that Mr. Arnell considered. Mr. Arnell did not reach his figure of £430,000 by coming to some higher figure and then discounting it by a percentage or adjusting it in some other way.
But at the end of the day, the judge, as he was entitled to, came to his conclusion not on the basis of the expert evidence, but on his view of the market evidence, which he thought was the best evidence of value. So where does this get you?
If the marketing evidence had been that a bona fide professional and properly organized marketing process had been carried out following the advice of experienced estate agents, then the price actually obtained in the market would undoubtedly have been good evidence of its market value.
But that's what the judge found at paragraph 55, isn't it?
That is precisely what the judge found.
Yeah.
But it is central to our case on ground 3 that did not happen in this case, and could not, and that did not happen in this case. And indeed, Mr. Plant didn't want it to happen in this case. But whatever he wanted, it did not happen. For the judge to have reached the conclusion he does, you would have to have had that would have required the person in control of the marketing to have been disinterested, or to have only had the interest of Newmarket achieving the highest price it could, rather than Mr. Plant's motive, which was to secure the property at as low a price as possible. I'm not at this point addressing ground 3, but that's our short answer to that. It was a flawed process, and I can explain in one sentence why it was a flawed process. A process that was designed to achieve the maximum price would have been one which followed the recommendation of Knight Frank, which was that after a short marketing period, you go to the last 2 or 3 bidders, and you invite them to submit their best bids. In that way, you get the highest figure that each potential purchaser is prepared to pay. We will never know what Mr. Plant's highest bid was, because all he ever did was to match the next bid that came in. He never overbid Birmingham Properties or any of the other earlier interested bidders. He was never asked, what is your maximum bid? Because the person who would have asked that question would have had to be himself. And he didn't ask himself that question wearing his hat as the agent of Newmarket with responsibility to get the best price. Because he was conflicted in the way he was, he had the system was one, and the bidding procedure was one, which did not secure the highest bid. If he had been prepared to go up to £600,000, then plainly the highest price that would have been obtained in the marketing of the property at that time, in a short marketing period, was not achieved, because all he ever did was match the Birmingham Properties. Because that is at this stage, my Lord will handle the short answer to that question. But I do concede, as I did, that that if there had been the kind of marketing process which the judge found that there was, then it was entirely open to him to reach his conclusion on valuation in the way he did, and indeed the way the Court of Appeal did, by ignoring the expert evidence, in the sense of not having to address all the differences, £6 a square foot, £11 a square foot, and all the other points, and just look at what actually happened in the marketing, rather than the more theoretical evidence of the valuers. Before we leave paragraph 17, can I just say, in the case of Mr. McBride, the relevant evidence which he gave that the judge did not have in mind, and is not reflected as having been something that he had in mind when reaching the conclusions he did, and that would be in particular the conclusion in paragraph 52. Page 563, he accepted that the lack of a for sale board helps an inside buyer. 641, that all his instructions came from Mr. Plant. 647, that it was Mr. Plant who introduced Mr. Fielding. 648 and 9, that he never in fact met with Mr. Fielding. He had no dealings with him. He trusted Mr. Plant to have those dealings. And 654, he had no idea at the time that Mr. Plant was behind the Gibraltar companies. So he is plainly not able to perform his role as one of the joint agents in the sale, because he has no idea that the fielding bids are in fact the plant bids. Had he known that, then clearly that would have had a very significant impact on the way that the sale process would have been conducted and how it would have been reported to the bank. My lords, can I jump now to ground 3, which is internally page 17 and in the bundle page 1930 of our case, where we deal with the equitable claim to contribution. We start off, unsurprisingly, by referring to the case of Dering and the Earl of Winchelsea, which is at 2430 in the bundle. And I think both sides regard RBS and Highland Financial Partners, which we cite in paragraph 34 as a helpful and up-to-date authority, and that's at 2856.
There is authority of the board also in relation to the points considered in Highland. It's a case called Sang Lee Investment, and it's a judgment of Lord Brightman, and he indeed said the same thing, that he said, to disentitle a plaintiff to relief, the alleged want of probity had to arise in the transaction and had to have an immediate and necessary relation to the equity sued upon.
Thank you, milady. I don't think I knew that authority, but there's nothing surprising in what you've just read out from it. It's entirely consistent with the authorities that we and indeed my learned friend rely on.
But it is the board.
I appreciate that. Just to assist, the paragraphs cited 158 and 159 from the RBS case are at 2905 of the bundle. On the following page, 2906, is paragraph 163, which is also worth looking at. The Willis case that we mentioned in paragraph 35 is at 2617. And the passage cited from the judgment of Lord Justice Parker is at page 2618 of the bundle. I was going to add that the Willis case was one involving a promissory estoppel, a case where I think it was the defendant was claiming through promissory estoppel the right to live rent-free in accommodation for the rest of his life. And he had produced false evidence to support his contention that he had spent money relying on that promise. And when that was revealed, the judge dismissed his claim, and that was upheld by the Court of Appeal in the passages of Lord Justice Parker and of the Master of the Rolls that we rely on. In paragraph 37, we deal with the law relating to the reduction of contribution. And paragraph 38 we set out, they are in the bundle from page 392. The first paragraph there is which begins with "if plant is beneficial owner," that comes from paragraph 69, and we then have 70 and 71 and 72 on the next page. It is the these were findings of fact by the judge in the BVI. English law had to be proved by expert evidence. And the judge in paragraph 72 is making a finding of fact as to what English law is. He
Is that correct? That is there some authority which says that in BVI, the English law must be proved?
Yes, indeed. BVI treats English law as foreign law, and therefore, unless you are going to rely on the default presumption, which is an issue which I believe has been before this is before.
Yes, but here the BVI law is the same as English law.
No, the fact that BVI law is the same as English law does not make the judge's finding a finding of law. In the context of a BVI judgment, it's a finding of fact. It's very similar to a case.
Well, I don't think it matters whether it's a finding of fact, does it, for this purpose? It's just just a matter of practice whether or not it was usual to have experts in the BVI on English law.
Where you are contending that English law differs from BVI law, which in most situations you do not, but where you are contending that, or where BVI does not have a corresponding statutory provision, because one of the issues in this case, or one of the issues dealt with by the two experts, was whether the 1978 Contribution Act applied in the BVI. That was treated as an English law issue, and therefore that was dealt with by experts on English law. It is, from my personal experience, I know it's not that unusual for expert evidence of English law to be provided to jurisdictions such as the BVI, where one or other of the parties is contending that English law and that English law, I'm so sorry, that BVI law does not correspond with English law, and there are differences between the parties on that.
I see. But in relation to the law of guarantees, there are no relevant statutes in this case. Anyway, there we are. It's an observation.
May I just say that there is an analogy which arose something like 20 years ago or more on an appeal from an arbitrator under Section 69 of the Arbitration Act. It was a case where a contract was subject, as I recall, to Indian law. There was an issue of contract law where it was, I think it was even common ground that the principles applicable under Indian law are the same as English law. The arbitrator made a finding, and an attempted appeal under Section 69 was dismissed on the ground that that finding of English law was to be treated as a finding of fact.
Okay. Thank you.
I would add to paragraph 40 that Mr. Smith, who was Pickle's expert, in the bundle at page 1543, deals with this issue at paragraph 52 of his report, and the judge's conclusion in paragraph 72 would appear to be based on his acceptance of that. Mr. Smith, paragraph 43, which is at 1540 of the bundle, also considers that point. If there is any difference between the experts, and we've suggested there isn't, but plainly the judge followed Mr. Smith as he was entitled to, there was no appeal from this finding to the Court of Appeal, and we submit that it's not something to be reopened at this hearing. We, from from paragraph 42 onwards, make our submissions in relation to the misconduct of Mr. Plant. And we quote from his cross-examination, and in paragraph 43D, I'm so sorry, we make the submission at the end of paragraph 43E about how that evidence on why he, in his mind, regarded acquiring the properties, we say at an undervalue, as relating to the guarantees. He was motivated, it would appear, from this evidence to proceed with the secret purchase of the properties because he hoped to profit from them by an amount that would cover the liability under his guarantee. And it would be, I think, it would be convenient at this point for to make our submissions relating to the link between the misconduct of Mr. Plant on the one hand, and his claim against Pickle for equitable contribution on the other, because there's no doubt from the authorities, including the Sanglia investment case, that I have to satisfy the board as to that linkage and a sufficient degree of linkage between his claim against Pickle on the one hand and his misconduct to bring myself within the clean hands doctrine, which is another way of expressing that if he has behaved inequitably or unconscionably, that of itself is a reason for depriving him of any entitlement to claim contribution against Pickle. The first point is that Mr. Plant conceded that he kept his bid secret from the bank because it was likely or possible that the bank would require as a condition to agreeing to the sale to the Gibraltar companies and to lifting its charges, including the charges over the properties, that either the debt would have to be settled, or at least the guarantee liability would be settled as a precondition for agreeing to the sale and lifting the charges. We set out the relevant evidence on that in paragraph 43D of our case. And the we also rely in this context on paragraphs 30 and 141 of the judgment of Mr. Justice Leon, where he refers to the evidence of Mr. Thompson, and plainly the bank's position was that if it knew that that it was a guarantor who was buying the property, they would require all matters, including the guarantee, to be settled. And indeed, Mr. Plant conceded that the whole debt might have had to be discharged in order for the bank to approve him as a purchaser. So we have that direct link between the secrecy of his bid and indeed the way that that corrupted the sale process, and the liability and the settling of the guarantee. Next, as we were looking at in paragraph, and as spelled out in paragraph 43E of our case, his aim, and we cite there the relevant evidence, his aim in purchasing the properties, or at least one of the motives in purchasing the properties, was to be able to recoup the payment that he knew he would have to make in order to settle his guarantee liability. And in this context, I draw attention to paragraph 16 of Mr. Plant's second witness statement, which is at page 1163, where he explained that motive. He said he was going to try to mitigate he says, our exposure on the guarantee, because he believed that there was a long-term potential in the properties. So his interest in the properties was not in the net rents, if any, that they were producing, but in their development potential. So his interest was in making a substantial capital gain. And remember, he had intimate knowledge of these properties. The reason why, unlike the other bidders, he was able to exchange contracts within 24 hours of his bid being accepted was because he had no need to carry out due diligence. He didn't need, his solicitors didn't have to ask for copies of all the relevant leases and the like. He was able to exchange contracts straight away. It's another secret advantage that he had over the other bidders. But he himself has admitted that the very purchase of the properties was linked to the party's liability under the guarantee. The third point we make is this, that if the bank had discovered that he was behind the Gibraltar companies before completion, there was the very real prospect that the control of the sale process would be taken away from him and either given to Knight Frank, or at least the bank insisting that Knight Frank and Mr. McBride follow the advice of Knight Frank, and in particular that they would follow the Knight Frank recommendation of a process that would lead to the parties making their highest bid. So the advantage which he obtained included avoiding the very sale process, which we say he was corrupt in the way that it was left to him secretly to conduct, being discovered. And this represents inequitable conduct of the highest degree. And it's inequitable, and it's because the I accept, of course, that there was never going to be a sale price that was going to come anywhere near the £4 billion loan, outstanding loan, and in that way reduce or eliminate the guarantee liability. There was always going to be liability under the guarantee. But it is sufficient in our submission that he indulged in a process that enabled him to obtain the properties and to benefit in the future from that, and from his intimate knowledge of them, by deceiving the bank in the way he did.
I wonder if I could raise with you, everyone has agreed that the test is that the want of probity has to have an immediate and necessary relationship to the equity sued upon. If whatever Mr. Plant did in breach of his fiduciary duty, at least to his insolvent company, had no effect at all on the liability of either of the co-sureties, what basis does the court have for saying that there is an immediate and necessary relation to the equity sued on?
Well, I remind your lordships that in this when dealing with the nature of the misconduct which the authorities have indicated is relevant, that extends to misconduct in the way that a claim is asserted or the litigation itself is conducted. And the Willis case that we referred to in paragraph 35 is a good example of that.
Yes, but in the Willis case, did the dishonesty not was the dishonesty not a necessary component of the claim?
The dishonesty, the dishonesty extended to creating false evidence, or false documents, supporting a claim of expenditure. And whether you create false documents to support a false case, or you create false documents to support a good case, which is unfortunately uncorroborated, the result is the same. But I mention that in simply in support of the submission that one has to take a broad, the broad view of the misconduct in question that is consistent with and reflective of the way that equity will look at inequitable conduct in this context. And the misconduct in the sale of the properties, we say, is itself sufficiently close to the claim under the guarantee, because the bank effectively had two forms of security. They also held a debenture over the Newmarket, and I think also the property owning companies, and they may even have had a charge over the shares. There was a whole security package, but the relevant security, as the judge fully appreciated and is inherent in the way both parties have conducted this litigation, the relevant security was the charge over the charges over the two properties and the guarantee. And in the eyes of the bank, the two were two forms of security and were interlinked. And that's apparent from the evidence of Mr. Thompson, which the judge accepted, despite it being given by way of hearsay. And he preferred that to the evidence of Mr. Plant, who disputed that which was being asserted by Mr. Thompson. The bank saw both securities as relevant. Of course, if there is a sale to a stranger, then the question of the guarantee gets settled afterwards. The bank is not going to hold up a sale to a stranger in order to put pressure on the guarantors to settle, or indeed to investigate whether the guarantors are in a financial position to settle. The bank was misled by the misconduct of Plant in the sale process, and agreed to a sale at 475, which it would not have agreed had it known the true position, or would not have agreed without investigating the matter in far more detail and wanting independent professional advice, not relying on Mr. Plant on this. And that is in the context of one of the two forms of security held by the bank. And therefore, we submit that even though it would not have affected the ultimate liability under the guarantee, because the absolute maximum after a 15-month marketing period that could be achieved for these properties was going to be only £1 million. There was no question of the full guarantee liability not having to be met in due course. But it's because the bank linked the two that we say that the misconduct in the sale is itself, through that linkage in the mind of the bank, and a very natural and obvious linkage in the mind of the bank, relevant to the guarantee and relevant to the way that the bank would be enforcing the guarantee. Our fourth point is that Mr. Plant did ultimately settle with the bank in 2013 in circumstances where they asked him for a statement of assets and liabilities, and as is clear from the evidence that we summarize in paragraph 43G of our case, he refused to do so because he could not give a statement of assets without disclosing his ownership of the Gibraltar companies, his beneficial ownership of the Gibraltar company. And therefore, the ultimate settlement achieved with the bank was one which at that point quantified both parties' liabilities to the bank, and thus the quantum of his settlement with the bank, and thus the quantum of our 50% of what would otherwise be our 50% equitable contribution, is clearly seen to be linked with his secret acquisition of the properties through the Gibraltar company. That's the final linkage that we rely on. And the only other point I make on linkage is the judge understood that we were relying on that link between the misconduct of Mr. Plant and the guarantee, as is apparent from paragraphs 21 and 22 of his judgment, in addition to the undervalue points that were perhaps more in the forefront of the Pickle case at that stage. I note that it is 11:45, and my Lord Hodge wanted a prompt at this stage for a short adjournment.
Thank you very much. If that is a suitable place for you, Mr. Tager, the court will adjourn for 5 minutes and then resume. All you need to do is to mute your microphone and stop your video, and we'll return to the same meeting. Thank you very much. Thank you, Mr. Tager. We can resume your submissions on behalf of the appellant. Thank you.
Thank you, my Lord. Can I take the boards to paragraph 46 of our case?
Could you give me the electronic number, please?
1940.
Thank you.
This is dealing with a point which the judge regarded as relevant, and the Court of Appeal very relevant, that Mr. Sharp had been offered the opportunity, after exchange of contracts, when apparently Mr. Fielding had dropped out, to come in on the transaction on a 50-50 basis and declined. We make it clear in the third line of paragraph 46 that it was that it was to Mr. Sharp that the offer was made, not to Pickle. He declined. It was never suggested that Mr. Faller was aware of it. This was not something explored with Mr. Faller at all in cross-examination, nor was Mr. Sharp asked whether he had discussed this at the time with Mr. Faller. So this was an invitation to Mr. Sharp, not an invitation to Pickle. And we are either criticised for not taking it up, or it is being said that that if there was an undervalue, that we're seeking to benefit from it now, when we declined the opportunity to benefit from it by entering into a joint venture on the purchase of the properties with Mr. Plant. The only point I would add to those set out in subparagraphs A, B, and C is that in addition to sharing the benefits, benefits of the spoils, as we express it at the end of paragraph B, there's also the benefit of buying the properties with the deception of the bank continuing, and therefore without having to settle with the bank on either the loan or at the very least the outstanding guarantee liability. In paragraph 50, we cite from paragraph 69 of the judgment, where the judge uses the phrase in I think it's the 8th line, if Plant is a beneficial owner of even 50% of the Gibraltar companies and so on benefited. It is our submission to the board that the judge is looking at the intervention or the use of the Gibraltar companies correctly. It matters not whether it is the Gibraltar, whether the properties belong beneficially to the Gibraltar companies, and if they have bought the properties at an undervalue of say £200,000, that amounts to an instant profit, albeit not realised at that stage, to the shareholder of £200,000. There is a reflective profit in the shareholding, in the beneficial shareholding that Mr. Plant enjoyed, something which the Court of Appeal ignored because of the very narrow view that they took of this aspect of the case, which actually prevented them from considering it more thoroughly in the way they should have. The Court of Appeal, in paragraph 49 of the judgment, which we cite at page at paragraph 51 of our case, focused on the opinion in the report of Mr. Millett, who was the expert for Plant, but ignored the way that Mr. Smith dealt with the matter, even though plainly in our submission, the judge relied on and preferred, if there was a conflict, the evidence of Mr. Smith. At page 1543, at paragraph 52 of his report, he said, however, the basis of the equitable principle is that co-sureties are to be treated equally if the facts as found by the court are that Mr. Plant procured the sale of the properties to the Gibraltar companies. Pausing there, that in substance was the finding. In fact, it had ceased to be controversial by the end of the trial, and that Mr. Plant has thereby in substance benefited from the acquisition of the properties. Then he will have received a benefit which the other co-surety, Pickle, did not receive. In these circumstances, if Pickle is prima facie liable to make a contribution to Mr. Plant in respect of the amounts paid under the settlement agreement and legal costs, then in my opinion, the English court would be likely to hold that the equitable principle is engaged, such that Mr. Plant is required to bring into hotspot and share the benefit which he received from acquiring the properties at less than their true value. And that is the basis. That's the basis upon which the judge proceeded. And for the reasons I submitted earlier, it was not open to the Court of Appeal to disregard that finding, and in fact, they don't appear to have appreciated that that's what they were doing by relying on the way that Mr. Millett had addressed and expressed these.
Mr. Taylor, when I was preparing for this hearing, I read that paragraph, and it gave rise to a question in my mind, and I wonder if you could help me. Mr. Smith at paragraph 52 is opining that the fact that there is a benefit from undervalue gives rise to an obligation to contribute because co-sureties should be treated equally. But are there, to your knowledge, any authorities where the doctrine of coming to equity with clean hands has been applied against a claimant when the impugned conduct has has not operated to establish the equitable claim or enhance the quantum of that claim? I mean, are there any authorities that you can assist us with?
We have not found any authority that in the context of what you have to satisfy, on which you have to satisfy the court, as to what I call the close link between the misconduct or the inequitable conduct and in this case, the liability under the guarantees, where a company has intervened. But there are many instances where, when seeking equitable relief, the intervention of a company is something which a court would not regard as impeding its ability to grant equitable relief.
I'm taking the company out of it altogether, and asking the question more widely. If Mr. Plant himself had purchased the property and had contracted to purchase under a pseudonym and had eventually taken title to the properties, let's treat paragraph 52 as operating on that hypothesis. I renew the question: are you able to give us any authorities where the courts have applied the doctrine, where the impugned conduct has neither assisted in establishing the legal claim or enhancing the quantification or establishing the quantification of that claim?
The answer is no.
Thank you.
But I would only add that the misconduct does not have to successfully affect the liability in question in order to dirty the hands of the party coming before the court for equitable relief. It is sufficient for the misconduct to be sufficiently close to the nature of the relief being claimed that a court of equity will say to the claimant, you have behaved inequitably and have therefore deprived yourself of the right to ask this court for equitable relief.
Well, the reason I asked that question was I think everyone is agreeing that the test is that there has to be an immediate and necessary relation. On your formulation, where is the test of necessity met?
It's met with the with Mr. Plant having avoided having to settle either the loan or the guarantee as a condition for the bank accepting his price, and therefore he was able at that stage to complete the purchase without having to settle Newmarket's outstanding loan or his guarantee liability. You also have that close link in his motive for purchasing the properties. And you also have that close link in his reason for not giving the bank the statement of assets to continue at that stage to hide from the bank the fact that that he is behind the Gibraltar companies, and therefore the bank agreed to the settlement agreement and to settling for less than the full amount of the guarantees on that false basis.
Thank you. Lord Stevens has a question.
Oh. Perhaps I could also ask a question in the same area, or roughly the same area, and that is, assume for one moment that the open market, the proper value was £1 million, or whatever figure you like to take. The guarantee would have been exactly the same. Your client's liability for an equitable contribution would have been exactly the same. Why is it then that by relieving Pickles of its responsibilities under the guarantee is the equitable thing to do in circumstances whereas here the loss is to the bank? Well, why should Pickles take advantage of the misconduct, alleged misconduct, may I say, of Plant to relieve it of liability. Why is that equitable?
Yeah. Lord, this is the kind of argument that is raised when a party asserts an illegality defence, of which there was more scope historically than there is now. And we would submit that your lordship is looking at it the wrong way. The fact that a party who, if he would have behaved himself, would have been entitled to equitable relief, has through his misconduct lost that, is losing the benefit of that, is losing his right to that relief because of his misconduct. And a consequence of that is the fact that the defendant is going to be better off because the misconduct of the claimant has deprived him of relief to which he would otherwise have been entitled. But that is not a reason. I can't say that is not. That may be a factor that the court would weigh in the balance when considering the impact of the dirty hands, the unclean hands. But the focus of the court, we submit, is a public policy consideration, namely that a party who has behaved inequitably in a relevant manner deprives himself of his right to equitable relief. And it's inherent in the nature of equitable relief. The freeholder in the Willis case was able to obtain vacant possession of the property, even if the relevant grounds for promissory estoppel might have been made out had the occupier, the defendant in that case, not forged the document he did. But the court, it's clear that the Court of Appeal were quite adamant that if you behave in that way, in asserting your equitable rights, that itself will deprive you of them. Lords, Milady, I turn now to the sale at an undervalue, which we deal with from paragraph 54 in our case, page 1945. You have there in paragraph 55 conveniently set out the evidence I've referred to earlier regarding Mr. Farrow's 8-week marketing figure. And you see in paragraph 57 of our case that the Court of Appeal accepted that the judge didn't mention the oral evidence of Mr. Farrow. He said he did have regard to his expert report, and particularly his supplemental expert report, and the fact that Mr. Farrow suggested a market price of £1 million for the properties. There's nothing in the complaint. Well, they missed the point entirely. There was everything in the complaint. The complaint was that the judge only had regard to the 2 written reports and not to the oral evidence. And we expand on that over the page at A and B. And in the final sentence of B, we say the Court of Appeal should not have assumed that the judge had considered Mr. Farrow's oral evidence. Indeed, and we go on to say that the judge failed in his judicial task as set out in part. This is another example, we say, of the Court of Appeal not undertaking its appellate function by reference to the principles that we rely on under ground one of our appeal. With the 9 or 12 months delay and no other explanation, you cannot assume, as you might have done with a judgment delivered shortly after the trial, that the judge had in mind all relevant evidence, including Mr. Farrow's qualification of his £1 million, reducing it to £750,000 or so, if there is to be a forced sale. In paragraph 59B, at the top of page 1949, we refer to the development potential of the properties. That was, as I have submitted earlier, Mr. Plant's interest in buying the properties. So far as the experts were concerned, you will see from the joint statement that they signed off just before the trial, which is at page 1873 of the bundle, that the experts agreed that Wolverley House had medium to long-term development potential. They disagreed about the development potential of Smithfield House. Mr. Arnold contending that because of the leasehold interest, redevelopment would be difficult. And the Smithfield House was a leasehold with a term expiring in November 2053. So at the time, there was approximately 41.5 years to run on that lease. Wolverley House was a freehold. And of course, any development of Smithfield House, if it wasn't undertaken either in conjunction with the freeholder or with having negotiated an extended lease with the freeholder, would have had to be a development that would have made economic sense, where the term might expire in 41 years' time. But the development potential was certainly there, and in particular in the case of Wolverley House. When dealing with our challenges to the judge's findings on and the way he approached the expert evidence, which we set out at length in paragraph 60 from page 1949 and 1950, there is an additional point to be made, that in our submission, the judge misunderstood the purpose of this expert evidence. The purpose of the expert evidence, or at least one of the purposes, was to enable the judge to reach a conclusion as to whether, if marketed over an 8-week period, the market value is £475,000, or perhaps less, as Mr. Arnold suggested, or perhaps more. Because if the expert evidence would point to a higher figure, say £700,000, then that itself would be evidence of Mr. Plant's purchase at an undervalue, and of the fact that you cannot rely on the bidding. The expert evidence was there as to enable the judge to form a conclusion as to whether, even with the flawed, and I've called it a corrupt, sale process, which was conducted by Mr. Plant, using Mr. McBride, sidelining Knight Frank, and not following their specific advice, the judge, in reaching a conclusion on value, needed other evidence in order to enable him to reach a conclusion that, however unfair and inappropriate Mr. Plant's conduct of the marketing was, it nevertheless managed to achieve the market price. I said earlier that this was not a matter that one thing the experts did not do was to address the actual bids or to give any opinion regarding the sales strategy, either as conceived or as implemented. In paragraph 61 of our case, at the top of 1951, we address the way that the Court of Appeal dealt with this. And there is a curiosity that, and you see this in paragraphs 39 and 40 of the Court of Appeal judgment, where they inexplicably, where they irrationally suggest that expert evidence would have been of more relevance if there would have been a claim against the bank. And indeed, they were concerned by the fact that Pickle hadn't issued a Part 20 claim against the bank, and to sue the bank for having sold at an undervalue, relying on the Skipton case. This was, I'm not going to spend a lot of time on that proposal. I'll merely point out that the quantum of such a claim would have been zero. Even if the bank had, even if a different sales process could have resulted in £1 or even £2 million being achieved, it would not result in any damages suffered by Pickle, because Pickle would have been liable under its guarantee in any event. So there was no question of bringing in the bank, and let alone expert evidence then becoming relevant to a claim against the bank. The expert evidence was relevant in the claim against Mr. Plant, or the allegations of misconduct that Mr. Plant faced, including having those based on the acquisition of the property at an undervalue. The Court of Appeal dealt with this simply by reference to the bids, but we say that was an unreliable basis, because the very definition of market value is one that requires an honest and professional marketing strategy and its implementation. And secret bids with the sales process being controlled by the bidder, but by the successful bidder, is not such a process. And one can test it in this way. What was Mr. Plant's process? The answer is one that was designed to enable him to purchase at as low a price as possible. Hence, he only matched other people's bids, and as they increased, he had to increase his matching bid. It was through him that Newmarket and the bank were deprived of a sales process that would have established objectively what was the highest amount that Mr. Plant was prepared to buy, or was prepared to pay for these two properties. The Knight Frank process would have achieved that. Indeed, a dialogue between Knight Frank or even Mr. McBride with Mr. Plant to the effect of, well, what is the most that you are prepared to pay for this? That didn't happen either. So we do not know what an unflawed and a professional sales process would have achieved. But we have no reason to assume it wouldn't have been higher than 475,000. It's very important to make the point that Mr. Plant never suggested, when he matched the Birmingham properties 475, that was the highest he was prepared to go and would not go any higher. He never did indicate in his evidence or otherwise what that highest figure was. I previously mentioned, but I will repeat in the context of the part of the case we're looking at, that unlike any other interested purchaser such as Birmingham Properties, by masquerading as the Gibraltar companies, Mr. Plant was pretending to be a purchaser who was prepared to proceed on a 24-hour exchange without carrying out due diligence. The reality is the only reason why the Gibraltar companies were prepared to exchange contracts without undertaking the due diligence was because Mr. Plant was behind them and had no need for that due diligence. When on page 1954 in paragraph 65b, we say 8 lines up, it cannot be known what the prospective purchasers' final offers would have been, and that is if they would have, in the context of following a process that concludes with a requirement for best bids. I have concentrated on Mr. Plant, but of course we don't. There may have been others, especially Birmingham Properties, who, when asked to put forward not their next bid up, £25,000 more than their previous, have asked what their final best and final bid was, may well have been significantly higher. Again, that's something that we don't know. The in paragraph 65 on page 1953 at the beginning, we cite from paragraph 44 of the judgment that there were minor differences in the views between the two firms on marketing, such as the use of a for sale board or a brochure. The major difference which the judge missed was the requirement for best and final bids. Mr. McBride didn't publish in writing his sales strategy, but, and I've really highlighted that evidence, he conceded in a cross-examination that he took his instructions from Mr. Plant. So the actual sales strategy, the actual McBride sales strategy was Mr. Plant's sales strategy, and the main difference was in the way that the highest bid is to be extracted at the closing stages of the process, but the use of a for sale board is itself significant. It was recommended by Knight Frank. Mr. McBride conceded in cross-examination that the absence of a board assists an inside buyer, and he didn't know at the time when the question of board was being discussed, he did not know that Mr. Plant was to be an inside buyer. Had he known that, he may have taken a different view.
Would I not be right in saying that Mr. McBride gave a reason in his evidence in chief as to why he did not want a sales board?
Indeed.
Yes.
But that was in the context of him not knowing that there was to be an inside buyer.
Yes, thank you.
Once he knows there's an inside buyer, well, that tips the balance on that issue. But for that, the judge would have been perfectly entitled to accept Mr. Bride's reasons for not having a board, but he qualified that in cross-examination. There's one point I would add at the end of paragraph 65, and that is that the appellant's concerns also included the fact that the limited marketing that was undertaken failed to identify potential purchasers. And in Mr. Farrow's cross-examination, and you see this between pages 982 and 985, especially 983 and 4, he identified a company that he had spoken to, Salhere, who were local developers, who had told him that they were unaware that these properties were on the market, and he referred to others who he didn't identify, who were in the market at the time and who were unaware of this. Finally, my lords and my lady, in paragraph 68E on page 1959 of our case, we make our complaint that the Court of Appeal failed to properly explain its decision. And the explanation that we're given is they say that the fact that the respondent was involved in the advertising and in the bidding and that which might have evoked strong feelings, but ultimately had no effect on the marketing price. The Court of Appeal wrongly assumed that Mr. Plant's involvement in the marketing was limited to advertising. In fact, there was no evidence of whether or not he had been responsible for the sale either being or not being advertised in the Estates Gazette. That was one of the issues. It was to do with the control of the entire process and the formulation of the sales strategy and for dealing with the bidding. That was at the heart of our complaint, not his advertising, not merely the question of advertising. I note the time. I don't know if there are any points that your lordships and your ladyship is interested in that I have not touched. These are the submissions in support of the appeal.
Mr. Taylor, thank you very much. The court will adjourn temporarily to consider where it is on this appeal. Thank you. Mr. Peacock, we do not need to call upon you on this matter. we are satisfied that Mr. Tager has said all that can properly be said in his written submission and oral submission in support of the appeal. The board will take time to consider what advice it will humbly tender to Her Majesty, and the board will now adjourn. Thank you all very much.
Lord Milady, I'm grateful.